Hello. Today we are going to look at the arbitration process there is to resolve disputes about internet domain names. Say, for example, a domain name that you claim is really yours, or one that should be yours, or one which is being improperly used by some other business or person. Now, of course, you could go to court to achieve your results in that area, but going to court is complicated and that's expensive, and arbitration provides a means of achieving the same end but more economically, with less complication and certainly much cheaper than going to court. Arbitration, you might say, is like having a private judge. It's not in a court. It's, as I've said, cheaper and it's quicker. It doesn't have the legal forms and those terrible technicalities that hover around the law in almost every respect. So let's say, for instance, just to illustrate how this arbitration process could be used, let's say, for instance, you have a trademark that applies to your business, or a product that your business or you makes. And then you discover, unfortunately, that someone has wrongly registered a domain name that looks suspiciously like your trademark. And it might also look as if they're using that domain name for a website that's causing you a lot of heartache in your own business, or even in the way you use your own website for social or family purposes. So something has gone wrong. Now, there is an avenue for you to try to resolve those problems and to resolve them quickly and reasonably cheaply, and that's a compulsory arbitration process that you can use if you want to take action to get a domain name back, to retrieve it from someone else, or to stop them from using it in a completely inappropriate way. So arbitration is generally a good process. It has a lot to commend it, and I'm going to talk to you about a bit of that today. Okay, I've already made the point that arbitration is a good system, and one of its good features is that in the domain name area, it's actually compulsory. So you can force the person or company whom you think has your domain name to take part in a compulsory arbitration process that could result in you getting your hands on the domain name or solving the problem, whatever it is. Now, how does it come about that this arbitration process is compulsory? Because not many things are in this area. Well, it's compulsory because when people register a domain name and they press that submit button before signing up to the domain name and signing up to paying the annual charges for registration of the name, before they press that submit button, they actually agree to a compulsory arbitration process which will click into action if someone makes a challenge to their owning the domain name. That's what gives rise to the dispute, and because the process is compulsory and because they have agreed to it, you can take part in the arbitration process. You can make it spring into action in an attempt to retrieve what you regard as your domain name and the domain name which is presently registered in the name of the other party. So because that arbitration process is compulsory, it's a very attractive process to use if you really want to recover a domain name. If you went to court, you'd probably have to go to some court overseas because your defendant is probably overseas. The party who has registered the domain name in their name, they will probably be overseas. And you can take my word for it, you don't want to get bogged down in some of the procedures of the courts of some countries overseas. So all of those problems, the cost, the complexity, are avoided by having the arbitration process. And it's one which, when you find out more about it, I think you will agree is a very useful process for resolving disputes about domain names, and a very useful process for retrieving domain names which you claim are yours. Now, of course, you probably know what I'm about to say, but I thought I should say, before we go on, just a little bit about domain names themselves. Domain names are the connecting links that hold the entire internet together. As you know, the internet is a collection of connected computers. Virtually every computer in the world is connected to every other computer. And the way the computers find their way through one computer to the next until the one they're looking for, the way that's done is by means of numbers that are given to each computer, but which by a code are translated into an address in words that we all understand. And that is what the domain name is. It's a valuable means of communications, and I wouldn't mind betting that in a few years all commercial dealings, and certainly most communications, are going to be done by means of the internet. But domain names are also very valuable properties in their own right, and that's why people fight over them, and it's why you should understand this pretty slick process of arbitration to get returned to you a domain name which you believe is yours. So the point I'm making is that if there are disputes about domain names, then you can use this arbitration process. All right, we know that it can be used. We know that it's swift and fairly economical, but what would you have to prove if you wanted to take a case in the domain name area, and if you wanted to win it? What would you have to prove? Well, it's quite straightforward, actually. You have to prove three things. First of all, if you want to use this system, you have to prove that you have a trademark, because the whole basis of the scheme that we are talking about is I have a trademark, you have registered a domain name, and it is misleading people or confusing people, or it's being used to sell counterfeit goods or used in some other improper way. But the starting point is that you must have a trademark to begin with. Now you might think, well, that puts me out because I don't have a trademark that's been registered at the Trademarks Office. Well, don't despair, you don't need that. You need a trademark, but it need not be a registered trademark. If you can establish that in the marketplace, the name that you're relying on has come to be accepted, generally speaking, as the name of your product or your service, or your own name if you are, for instance, a film star or a celebrity and you use your own name in business, that could also be your trademark. We call them unregistered trademarks. And if you can show in the case that you have adopted this name, that you've always used Joe's Garage as your business name, people associate Joe's Garage with you, then you're not really going to have any real trouble in establishing that you have a trademark. Take, for example, there was a case a few years ago concerning Hillary Clinton. Someone had registered the domain name hillaryclinton.com and was using it for purposes that annoyed Mrs. Clinton because she was wanting to stand for politics in the United States, and she wanted to use this domain name for her website, and someone had taken it and had used her name, Hillary Clinton, as the entire name of the domain name. She didn't have a trademark registered, but she was able to proceed with the case because she could show she had an unregistered trademark in her own name. And that was because, why? Well, because she was in a business, and her business was writing books. As you know, she wrote a number of books under the name Hillary Clinton. That was regarded as a commercial activity. Therefore, her name, Hillary Clinton, was her trademark that applied to her business. So she was able to succeed in that case because she had shown that she had an unregistered trademark to her own name. Cedric the Entertainer, you might know, he was in Big Mama's house, only a bit part, but he also had a domain name case when someone registered cedrictheentertainer.com, and he was able to show that that was really the name Cedric the Entertainer that he took into the entertainment market. He was known by that name, and therefore that was enough to get him over the hurdle. He had an unregistered trademark in his own name. Other celebrities in the entertainment field seem to have better managers or better imaginations, and like Madonna, they often have registered trademarks, which are simply registered trademarks in their own name. So they have no trouble at all using the arbitration process. So if they can show they have a trademark, registered or unregistered, they then have to take aim at the domain name and say, look, that domain name that the other party has registered is the same as my trademark, or it's going to confuse people. People will think when they see the domain name that it's referring to me and my business, my product, because I have a trademark over exactly those words. Take, for instance, a case I was sitting on as an arbitrator not so long ago. The trademark concerned a health and gymnastic firm in the United States called Planet Fitness. And this company had a trademark, not surprisingly, for Planet Fitness. Now, some people came along and registered two domain names, planetfitnesschannel.com and planetfitnesswork.com. And they were using it for dodgy advertisements for the same services that Planet Fitness provided, but provided by competitors of theirs. So they took them on in this arbitration process and were successful. But in the course of being successful, they had established, as you have just heard, first of all, that they themselves had a trademark. Secondly, that the two domain names that were being complained about were really almost identical because they had the words Planet Fitness in them, and those additional words, channel and network, added to Planet Fitness, still left the result in the air that people looking at Planet Fitness channel would think, or probably would think, that it was a Planet Fitness domain name leading to one of their websites, which of course was not the case. You can imagine this gives rise to some difficult questions, say when words like apple or orange is used in domain names. If you use the word apple, to take an obvious example, in a domain name, and you're using that domain name for a website to sell computers, I think most people would agree, well, that's confusing, and probably deliberately confusing, to give the impression that the domain name is going to lead to a website of the Apple computer company that we all know. But if you were using the domain name that had the word apple in it and you were using it to sell apples, probably the computer company Apple could not complain, because after all, apple is just an ordinary word in the English language and anyone can use it. Okay, well, they are the points we should bear in mind for the first step. Just to go over it very briefly, the first step is you must, if you want to use this arbitration process, show that you have a trademark, registered or unregistered, and then you have to take aim at the domain name that you want, and you have to be able to say persuasively, people looking at this domain name and the website to which it leads, they may well think that this is a domain name that relates to my trademark, and that gives you the first hurdle you've overcome. You're now in the arbitration process, you have a good fight on your hands, and you've won one of the three steps that you have to take. So that's progress. Okay, what's the second step? The second step is that you have to show that the person who registered the domain name has no right to it. That is, that they stole it or copied it or wanted to confuse people, or perhaps they were just out to commit a fraud on the public. And regrettably, that's one of the reasons why some people, although they shouldn't do it, of course, it's why some people do register domain names. Let me give you an example. Say someone registered the domain name valiumaustralia.com.au, and they used that on the internet to set up a website to sell contraband Valium. Say they used it to sell artificial or copied jewelry or sportswear with famous brands, women's shoes like Jimmy Choo. Say if they used a domain name for that purpose, then you would have no trouble, would you, in saying, look, they have no right to that domain name. They should not be using it for that purpose. They're using it for a deceptive and misleading purpose. Whether it's Jimmy Choo shoes or football tickets or contraband pharmaceuticals, which regrettably it is sometimes, the way in which a domain name is used to sell those sort of things, you can come to the conclusion, okay, they may have the domain name registered in their own name, but they clearly do not have any right to it. But there are some cases where people do have a right to have a domain name in a particular name, even although when you look at it for the first time, you might think, that's very strange, or that's not right. Often you can have a domain name which you are entitled to, which on the surface you might think, their claim to that might be very weak. Let me give you some examples of it. If they do have the domain name and have been using it for a legitimate purpose, and doing so before the dispute arose and came to their notice, then that is a complete defense. You are allowed to have a domain name which is registered in a name that you have been using for a legitimate business purpose before a claim was made on you. It doesn't mean, of course, that all uses to which you put the domain name will be legitimate, because using a domain name to sell highly suspicious artificial pharmaceuticals under a different name from, say, Valium, that's not legitimate, that's very illegitimate. But if the person who has the domain name in their name can say, look, this is legitimate, I used it because and registered it because it was a name that was attractive to me and useful for my business, and I've never used it for any illegitimate purpose, if they can show that, then they are entitled to keep the domain name. Another example is if the domain name is registered in your own name, meaning that the domain name is your own name or very close to it. There was a very fortunate man in Toronto a few years ago who got himself involved in a domain name case. His name was Mr. Mani, spelled M-A-N-I, and he had very good choice in parents because he chose parents who gave him two given names, one of which started with the letter A and the other started with the letter R. So he was Mr. A.R. Mani, and not surprisingly he decided to trade on his name, which then became Armani, A-R-M-A-N-I, and he registered a domain name which was armani.com. Well, you can imagine Mr. Giorgio Armani went into orbit about this and was very cross about it. And Mr. Mani's defense was, well, it's my own name. And that defense was accepted. He was able to keep the domain name in the name armani.com. If you look at it today, you can see that once Armani, the company, lost the case, they obviously had to buy the domain name from him, because now, if you look at it today, you'll find it's a regular Giorgio Armani website. Now, another example, which is quite a good one, and Americans are very keen on this defense, free speech. If you are using a domain name for, say, a fan site, to post up photos and praise of your favorite novelist or film star or celebrity or DJ or whoever it may be, that criticism site comes under free speech, and you are allowed to use it for that purpose. Good criticism, bad criticism, a fan site, a tribute site as they are sometimes referred to, so long as it is not used for commercial purposes, can well give you a complete defense to the claim being brought against you. So they are some ways that you can show that you are entitled to keep the domain name because you have a right and a legitimate interest in it along the lines that I've just suggested. But if you can't get yourself under one of those headings, then you're in trouble. And if we just go back to the illustration I've been using today, where you are making the claim and the person you're making the claim against has the domain name, you have to show that they have no right to be using the name and that they cannot bring themselves under any of those defences or exceptions that I've just been telling you about. Okay, well, you've got 2/3 of the way now. You've satisfied the arbitrator on 2 of the 3 tests that have to be satisfied, and you have taken 2 of the 3 steps you must take in this process. The third step is probably the most important one and the most difficult to prove in some cases, and that is bad faith. You, again, are making the claim, therefore you will have to show that the person who registered the domain name registered it in bad faith. That is, that he or she had bad motives in registering the domain name and bad motives in using it. You will have to show both, that the domain name was registered and used in bad faith. Well, what is bad faith? Bad faith is misleading people, confusing them, engaging in a fraud. That's clearly bad faith. Doing any of those bad things with other people's property and names, selling contraband goods over the internet using the domain name, having had, say, a commercial dispute and trying to hang on to the domain name and pretending you're the company that you used to work for but no longer work for them, that's bad faith too. So bad faith has to be shown. In other words, you have to show not just that they have the domain name, but that they have it wrongly. There's an element of wrongness that you have to prove. And that, of course, will depend on all of the facts. Every case is different. Let me just mention one of them to you, which was not bad faith, and might remind some of you who spent misled youth watching video games. You would have been familiar with the game Legend of Zelda. Well, Legend of Zelda had a very keen young fan named Alex Jones, who was only 17 when he registered the domain name legendofzelda.com. And he used it to set up a website. He's still doing it, actually, 5 years later. He must be a very keen follower of this game. He used it for plot lines in the stories, for character development, for gossip, talk, chit-chat amongst his friends. He did not use it for selling anything. He did not use it for any commercial purpose to encourage people to go out and spend money that he would benefit from. No, it was just simply the academic, theoretical game interest that he shared with his friends and associates and other devotees and supporters of Legend of Zelda. So the arbitrator, in my opinion, quite rightly said at the end of this, well, look, that's not really bad faith. There's nothing bad about it. It's true he is using the name. It's true he's showing extracts from the game. It's true that he's using it to promote the game. But really, isn't that good faith? Because Nintendo, who was bringing the complaint against him to get this domain name, they were the ones who would be benefiting from the extra publicity that he got the game. It was not as if he was trying to put the game off the air. It was not as if he was trying to pretend that he had a rival game or a game that was in competition with Legend of Zelda. He was quite up and open about it. He was not diverting any customers to a rival game. He was simply saying, I love this game. This is what it's all about. We are all followers of the game. And here we are 5 years after he did it, and he's still doing it, so he must be very keen. And of course, he won that case for the reason I have just given. It was not bad faith. But if you find a domain name is being used, say for instance to suggest that you are a hotel or airline booking service, pretending that you're Flight Centre or something like that, that of course is bad faith. Okay, well, there are the 3 points that you have to establish, and we've now established all 3 of them. Let me just go over them very briefly so they'll be in your head. First of all, you have to show that you have a trademark, registered or unregistered. Secondly, you have to show that the person or business who has the domain name registered in their name has no right or interest in maintaining it. The third step is that they have acted in bad faith. And if you can establish those 3 elements, then you will succeed in winning the case and getting a favourable order from the arbitrator. The order that you want, of course, is you want him or her to order that the domain name be transferred to you. The arbitrator has power to cancel the domain name altogether, but by and large, people want the domain name transferred to them rather than having it cancelled altogether. There is, of course, a third conclusion that the arbitrator might come to, and that is that the person who has the domain name registered in their name actually wins the case. So if they win their case, the claim against them obviously is dismissed. So the arbitration process can result in transfer of the domain name to the person who is trying to claim it. Secondly, it could be complete cancellation, but of course they can always register the domain name the same day after it's cancelled, or the day after it is cancelled, so that's not much value. Or the arbitrator may dismiss the case and the domain name stays in the name of the person who registered it. Those points that I've been discussing with you and which are part of the arbitration process are what goes to make up the process for the big league of domain name cases, the .coms, the .info, the .biz. It is virtually the same for most country codes, as we call them. As you know, you can have a domain name in Australia which is .com.au. And with respect to .au domain names, like New Zealand domain names and like German domain names, there is also a dispute resolution process like the uniform domain name dispute resolution process we've been talking about today, which is available for you. I've been talking about the UDRP today, as it is called, the uniform policy. I've been talking about that because it is the policy and the law which applies to the big league of domain names, those that end in .com, .info, etc. Okay, what about the practice to be followed? What happens when you make a claim under this arbitration process? There are 4 providers of the arbitration services, and you lodge your claim in any one of those 4. You could have a look at their websites and you will get a lot of information about the forms you fill in. They're not too complicated. The fees you have to pay, they're not too high, to be honest. And those 4 bodies are the World Intellectual Property Organization, WIPO, W-I-P-O, the National Arbitration Forum, NAF, which is in the United States, the Asian Domain Name Dispute Resolution Center in Hong Kong, and the Czech Arbitration Court. If you are going to bring the claim, you will decide where you will put the claim, in which of these bodies, and you'll follow their procedures. I would suggest that you do a search on each of those bodies, have a look at their websites, have a look at how they conduct their cases, and you will very quickly decide whether you are comfortable with bringing your claim in one, or another of those four bodies, but they all do a good job. There are no hearings as there are in court. All the cases are done online, so you have to put your evidence in writing and with various exhibits to prove the various points in your case. There's a lot of procedure and information about this. I have a website myself which I try to keep up to date with a lot of information about domain names and about the arbitration process. It is www.domaintimes.info, and you'll find a lot of information there, and also details about how you can find the answer to any other problem that arises in this area. I should also say that it's another reason why this is a good system, is that you have a bit of a say when you bring a claim in who is going to be your arbitrator. For instance, you can ask for a 3-person panel or tribunal, and if you do, you have the right to recommend one member of that 3-member panel, and you also have a say in choosing the 3rd member of the tribunal or the panel. So they are some of the interesting procedural steps you'll come across, but as I say, look up WIPO or one of the other providers, look up my website, and you'll find, first of all, information there which will answer your problem, and secondly, you will be able to get in touch with any of us who will be only too happy to give you more information on this procedure. If you want to see how the cases go, look at the websites of those 4 providers, because one of the good things about this system is that all of the decisions, the 40,000, can you believe it, 40,000 cases there have been so far in this field, the decisions in all of those cases are up on the website of one or the other of the 4 providers of the arbitration service. Okay, finally, the presentation would not be complete if I didn't answer the question, well, what happens when we win the claim? How is that going to help us? That, I think, is the real question at the end of the day that has to be asked. And what happens is that the arbitrator makes an order of the sort I referred to before, either that the domain name be transferred, cancelled, or that the case be dismissed. And that order that the arbitrator makes is sent to the registrar from whom the person bought the domain name in the first place, and that registrar is told to transfer or cancel the domain name and make sure that it's in the name of the successful party in the arbitration proceedings. And if the registrar does not do that, although I won't go into all the details at this time, I can rest assure you that there is a fair amount of persuasion, and at the end of the day, these orders are actually carried out. One of the big problems about court proceedings is the difficulty of getting a court order enforced. In the arbitration process, it's not like that. It's comparatively easy, and I think I can say to you safely, any order made under this arbitration process will be implemented and put into practice. Is the system any good? Yes, it is. Any system that's produced 40,000 cases can't be all that bad. It's actually quite a good system. 40,000 cases that explain why a challenge to a domain name entitlement has been examined and resolved on. And as I say, those decisions are there for the public, so there's a public involvement in the process. Finally, I just repeat what I said before. This is a fairly new field for a lot of people, and don't hesitate to ask if you have questions you would like to ask to give you a better understanding of the process. I hope, however, that what I've said to you today will be a useful introduction, and it's only a first step. Obviously, I could not cover the whole field. It's a first step and was meant to be a first step. I hope it has been of value to you, and I wish you all the best in your own association on whatever side of the fence you may be with internet domain names. Thank you very much indeed.